This car here has been bugging me all afternoon. It keeps shining off there. Look, right, cross-eyed, right in my right eye.
Oh,
Right,
whose car is it?
I have no clue. Not mine, that's for sure.
Oh, somebody just parked there just to bug you.
Yeah, that's about it, right? Parked there to bug me, right? Okay, so here we go. Welcome to episode 117 of Spin Legal. We are talking about where will my case be brought, okay? And that's obviously an important question for many people who are facing court, who've never been to court. And we're going to try our best to answer some of that. So, okay, let us correct that. If you need legal advice, you can contact Invictus Legal 905-688-5598. Angela, you can contact her email as Angela@weareinvictus.legal. Myself is Peter@weareinvictus.legal, and we are Invictus.legal is the website. So there we go. All right. All right. Moving on. So if you yeah, okay. Why did that come up twice? Okay. Okay. Looks like it's come up 3 times, so I don't know. That's weird. Okay, so our question today, so many different types of tribunals and courts. Where will my case be heard? And obviously that's it's a very important question because there's lots of them, right?
Yep, there's lots of courts, lots of tribunals, lots of different places where people bring their cases.
Well, and I'm going to start off with one that you wouldn't think of as being a court or tribunal, but here we go. Screening hearings in municipal matters.
Yep.
They're a tribunal, just like anybody else. That's a tribunal. So if you've got, typically these sort of ones is if you've got like a ticket for too many dogs on your property, or you parked in a disabled zone without a disabled ticket showing, or something of that nature. Types of things that get dealt with at the municipal level, you basically deal with it there. That's a screening, and pretty well every municipality has got one. So we can already count there's 342 of those across the province.
Wow. Yep.
Right.
Yep. And they're using AMPS, the automated monetary penalty system, which is not necessarily a great system.
Yeah, and in fact, it used to be, other than for traffic tickets, the vast majority of municipal matters are being screened here, are being held in screening hearings rather than being held in proper courtrooms, independent.
In other words, you're guilty, but you're going to talk to us about how much we're going to fine you.
Yeah. Right, and that's what's wrong about this, is that in fact you should be able to go to a provincial offences court and argue your case. Now,
sometimes they're very wrong.
Yeah, and in fact, actually, but even so, the vast majority of times at provincial offences court, there's still the attitude of you're guilty unless you prove to me otherwise.
Oh yeah, that's where most things are. You're guilty first and got to prove yourself innocent.
Yeah. Okay, so many people think of this next one as magistrates court, but it isn't. It's provincial offences court, right? And actually, the term magistrates court is a combination of 2 things, because it's both the combination.
I in magistrates court.
Sorry?
Magistrate is TRATES.
Okay, all right. So he's straight. He's a straight magistrate, not a bent one.
Oh, yeah. Not bent.
There we go. All right, there we go. You see, magistrates.
Yeah.
Okay, and some of those, magistrate is a position that's held across the country, across the province. Justice of the peace is a magistrate, and they sit in provincial offences court, and they also sit in criminal courts of certain kinds.
Yep.
All right. So provincial offences court is essentially where you're going to go when you've got a traffic ticket.
Yeah. So generally, that's what they usually do if you're going to be going to provincial offences court. Somebody charges you, or they go before justice of peace to file charging papers,
Yeah.
or they write you a ticket, and then you go to the court to fight it.
You know, you've normally got a ticket that's in yellow. Oh. You've got normally a ticket that's in yellow that's about as long as that piece of paper, right?
Mm-hmm.
But it's narrow. It's only about this. It's only about this wide, right? Only about 4 inches wide, and it's about 10 inches long, 10 or 11 inches long, right? If you are, you know, the suggestion I would always say with this is go speak to a paralegal or a lawyer. Depends upon the offence that you've got.
Yeah, we'll tell you, like, if you feel that you were wrong or something, you need to fight it, plead not guilty, set a trial,
Yeah.
and get a paralegal to help you.
Yeah, exactly. Okay. The next class of courts that we've got is tribunals. And there's a lot of tribunals here. There's a lot of tribunals in Ontario. We've got 160 in Ontario, 160 plus in Ontario, and probably the same again federally. Right? Tribunals are there. Tribunals have a role of taking a lot of the minor issues away. For example, the Landlord and Tenant Board, which is a tribunal, which is there to take the load of the landlord and tenant type actions outside of the scope of the court.
Mm-hmm. Yeah, and these tribunals are specialized. In some cases, things can be held before the tribunals, and as opposed to going to court. Other places, they must go to the tribunals.
Yeah.
Many of these tribunals have enabling legislation that say that anything that has anything to do with the Residential Tenancies Act must be heard before the Landlord and Tenant Board.
Yeah.
And above that, if it's above the financial jurisdiction, probably Superior Court of Justice.
Yeah. But again, a lot of that starts within the LTB, right?
Mm-hmm.
The other thing is, of course, if you've got like a human rights type case, if it would be normally held within the human rights, that's a tribunal in Ontario.
Tribunal.
Yeah. And there are two tribunals. There's an Ontario tribunal. There's also a federal tribunal.
Federal tribunal, yeah.
Yeah.
And the thing to know is that in recent years, in recent decades, they've decided that people can't go court shopping anymore, or tribunal shopping. Like, for example, you can't put part of your case in small claims and then the other part of case in the human rights, for example, or landlord tenant.
Well, actually, and that's an important thing, because if your claim is 100% based upon human rights, because you believe, for example, you believe that the would-be employer, you were perfect for that job, and they discriminated against you because you are black, white, purple, green, and pink. You know, so you fulfilled one of the categories of, a potential violation. Then maybe your only avenue, of course, is to open up in the Human Rights Tribunal. And of course, if your potential employer was a federal one, then you'd have to go to the Federal Human Rights Tribunal.
Mm-hmm.
Right. If you've got, so that's the only way in which you can pick. But again, if you've got a small claims court whereby, my client's alleging that your client damaged his car and that he did so on racial grounds or something like that, that becomes two-part, because A, he damaged the car, B, the question of race comes up.
Yeah, generally you can get human rights damages from the court.
Yeah.
But you'd have to articulate that in the pleadings.
Yeah, and the same with, of course, if you've got a human rights type claim that touches the Landlord and Tenants Board as well as the Human Rights Tribunal, you can have that tried within the Landlord and Tenant Board. In fact, it's probably easier to get it heard in the LTB
rather
than the
than
LTO these days.
That it takes for things to go through the Human Rights Tribunal is not bad, but they've been severely defunded over the last couple of years or few years, and it's difficult to get a case heard. And this was one of the problems at the Landlord Tenant Board till everybody started complaining, and then they hire a bunch of new adjudicators and actually staff the place.
Well, that's been one of the, of course, one of the big complaints that we had about the Landlord and Tenant Board about 3 or 4 years ago was that it was seriously short on adjudicators, and but now the Landlord and Tenant Board has seemed to have done a number of things to speed up to increase the speed of service. Although if you're waiting, I get it that no matter how fast they've made it, you still feel as if you're waiting forever.
Yeah.
Okay, so going from tribunals to courts, the obvious first one that most people think about when we're talking about courts is criminal. So there's 2 areas with criminal court. When it comes to criminal, the vast majority of prosecutions happen in the Ontario Court of Justice. The other area in which you can get criminal activity is Ontario Superior Court of Justice. Right? So there's 2 courts. What are the difference between the 2, Angela?
Ontario Court of Justice is basically when you're doing things for 1 year, 2 years less a day for criminal court. And it's often the first appearance for some of the other cases that may be more serious, unless the Crown will go try indictably, then it goes into the Superior Court.
Yeah. So if they are okay, so for first appearance for a Superior Court matter, it's
like the Court of Coordination appearances.
Yeah. That's the Court of Justice. The Superior Court is when they've already made their mind up as to which direction the court is going in.
Mm-hmm.
Yeah. Okay. The other areas that come into the Ontario Superior Court of Justice is Small Claims Court.
Yep. Small Claims Court is a part of the Ontario Superior Court of Justice, even though it has a limit of $50,000, and instead of being heard from a regular judge, it's heard by a deputy judge, and this is where people take the cases. The only thing that Small Claims Court can't do is they can't provide equitable relief.
Yeah.
Okay? Except in very narrow circumstances, like writ of delivery, for example, enforcing a certain type of settlement that you might have come to, like say in terms agreement, things like that they could enforce.
Well, they can enforce like a landlord and tenant.
Yeah. That's just an order, that they transport, and you just go through the enforcement process. But say, for instance, if you can't adhere to a terms agreement, somebody can bring it to a terms hearing at small claims, and then they can enforce that.
That's what I was meaning. There was a whole range of things that you can do. For example, the tribunal hearing now is held over into the Small Claims Court in order that we can in order that it basically can be enforced.
Yeah.
Right.
Yeah. So you have to transfer the judgment to a small claims, and then the Small Claims Court will use for garnishment, for examination, debtor examination, different types of enforcement.
As a percentage, what do you know if there's a recorded percentage that do move from from the tribunals to the court?
It's hard to tell. I mean, if people want to do this, they could. And sometimes people are paid. Okay, you won fair and square. Here you go. Other people even settle it after they go to court, and then they
Yeah,
decide that they're going to
yeah,
accept a smaller amount, just do it. Right?
yeah. Yeah,
Final.
we had one where basically the opposing counsel basically came around, wrote a check, and here we're done, right?
Yeah, because
So
they don't want to go through all the hassle.
yeah, they
There's
fought.
others where you bring it over to the court because every time you write to them and write a demand letter that now you owe X number of dollars, and they ignore you. Ignore you. So it's time to start getting action and put the
Yeah,
guns
yeah,
to the test and go for it.
yeah. The other court that's in the Ontario Superior Court of Justice is Family Court.
Yep, and they got their own court. You have to know that some courts for family court are still heard in the Ontario Court of Justice, and or the like split between Superior Court of Justice and Ontario Court of Justice, because some is federal, some's provincial. Okay, so the federal is the Superior Court of Justice. These are federally appointed judges. Okay, other than deputy judges, they have a different process for that. But the Ontario Court of Justice is for provincial stuff, for support, custody, and visitation, that sort of thing. Okay, but
Yeah,
the
and
Federal Court of Justice deals with divorce, property division, that sort of thing.
yeah,
So if
yeah,
you have a family court at the Ontario Superior Court of Justice, they used to be called unified family courts. So they put the Superior Court and the Ontario Court together and made it a unified family court. So I think more and more jurisdictions are getting them. We have one of those in St. Catharines.
mm-hmm,
Okay?
yeah,
And it's a lot easier. The forms are very basic. They just found online. You can put them in and deal with it. And they're less complicated with dealing with one court than you have to go to another court once everything has to go back to property
yeah.
division. Okay? There's
Okay.
various things but having a single judge go through the whole thing under a family law case, I think that would be a great idea with a lot of it. I'm not sure if they do that, but I think it would be a great idea if you do.
Well,
Because
and of course,
familiar with the case, familiar with the family.
one of the things about family court is that if you've got kids involved in there, and say the kids are 5, 6 years of age, that actual case may stay open for 10 or more years, mightn't it?
Mm-hmm. Yep. Some of them do, or they come back later on.
Yeah.
Okay? Suddenly, like the husband might have abandoned the kid as 2 years old and left.
Yeah.
And 10 years later, suddenly he wants to take custody.
Yeah.
I would look at that very bizarrely, but however, that's something that does happen.
And there might well be valid reasons for it, because, for example, if that particular father was in prison, now wants to take a more active role in it, and of course he's got no choice but to come to the family court on this.
Yep, there's a lot of issues. Children's child protection cases are also heard in family court because they want to look after children. Anything to do with children is heard in family court. For children under 12, they're also heard through the family court system for anything where there might be something quasi-criminal. So through the family court system. Mm-hmm. So these are things that get dealt with that way.
Okay, but not the actual child criminal trial.
Well, if there's a crime, a serious crime, but the child's older than 12, then they would go up, and then they have to have a determination whether they're going to hear them as a child or as an adult.
Yeah, okay.
And there could be arguments for either side.
Yeah, and we're not really going to go into that,
No,
but there's a whole...
That's very serious things, because it used to be the Juvenile Delinquents Act and became the Youth Criminal Justice Act, and it just carried on with different names.
Yeah. All right. The next one to look at is divisional court. Divisional court branch hears basically most applications for judicial reviews and many appeals from administrative tribunals. It also hears certain appeals and decisions made at civil and family proceedings.
Yeah, exactly. They're very limited, but you have to go to the right court.
Yeah.
And sometimes people, even lawyers, they bugger it up. Yeah.
Yeah. When they say,
like if you heard your case at a tribunal, landlord tenant court, you don't like the decision, you feel they made an error in law, that goes to judicial review. It's not the same as an appeal. Okay? There is a lot of issues, difference between judicial review and appeal. Now they're starting to think about rights to appeal, from that up ahead. But there's a lot of processes that would be involved, because if you have to appeal things, like appeal would be fact and law, judicial review, did you make an error in law? There's a lot of different arguments that could be made on either side. So divisional court would be where you go. And if you don't like the divisional court decision, then you go to the Ontario Court of Appeal. Did you have to get leave? You have to apply for leave.
Yeah. And applying for leave is basically a formal application for permission.
Yeah, exactly. Is there a chance to succeed?
Yeah.
Okay.
Yeah.
So in other words, I'm not wasting the court's time.
Yeah, and exactly.
The decision, I just don't bring that, but there has to be a reason why you're bringing it to the Court of Appeal.
Yeah. And exactly, the last thing they actually want in that particular case, if you're going to the Court of Appeal or higher, is actually stupid cases going there, right?
Yeah.
The next one we need to actually cover is actually the civil court. So we've covered family, small claims, etc. The civil court is there for the claims that are larger than the 50,000 normally.
Yeah, like there's a simplified procedure, which goes up to, I believe, to 200,000, I believe, and then after that's regular procedure. What you would have, that simplified procedure is where you have these higher than the small claims court cases, but may have less steps that you have to take. So it's less expensive, you have a certain length of time for discoveries and certain types of things like that, but you don't have the extent where you're in court for years, where you're looking at suing for millions. Where sometimes 10 years would be too short to get it heard.
Well, and the irony here, of course, is that when you're talking about the simplified procedure, you can still have complex questions of law being raised there. In fact,
even small claims, you can have complex questions.
Exactly.
Yeah, it's not necessarily what the law is that you're disputing, but often the value put onto the claim.
Yeah.
And
just because
do it. And then the thing is, you're going to sue for $100,000 or $120,000. It's too big for small claims, but you still want to have some kind of abbreviated process.
Yeah. Well, the other thing, of course, is that you could have a matter that's only 30,000, but yet it's an important point of law.
Yeah, exactly. I've seen it before where one person tried to run a family law case in small claims, and that got thrown out really fast, didn't it?
Yeah. Those tend not to be liked anywhere. They don't get accepted in any jurisdiction.
Yeah, the deputy judge actually practiced family law and he threw it out.
Yeah. And basically there's only one jurisdiction when it comes to family law type matters, and that is the family court.
Yeah.
And that doesn't matter, the claim that she took the family Bentley and owes me money for that. Doesn't matter whether it's that or she spent on the credit card or what, These are
things that has to arise coming from the relationship, as long as it's considered to be a relationship, like a common law or a marital relationship, and how it came up as a result of that relationship. So it's very different than, say, I just dated this guy for 6 months, but then he borrowed money from me, then he took off. That's different. You can go to small claims court and collect it. Yeah,
exactly. All right, moving on. This is the big one. This is the one where we get a lot of in Ontario. We've got a lot of the key decisions in this, which is the Ontario Court of Appeal. So basically, the Ontario Court of Appeal is the final level within Ontario for decisions, and they can be in civil matters, criminal matters, family
matters could be brought up that way.
Provincial offences, administrative law, and they're all about points of law.
Yeah, and these are all points of law that get decided, issues get defined, constructed, various things. And this is why people have to apply for leave, to make sure that this is the type of thing that an Ontario Court of Appeal should hear. And it's quite interesting because these Court of Appeal decisions are binding on all the lower courts.
Okay, so if you got through a Court of Appeal decision and you want to go somewhere else, where do we go?
Supreme Court of Canada. Again, you apply for leave to go to the Supreme Court of Canada. And if the Supreme Court of Canada declines you, they just say no. They don't give you okay. But if they do accept it, then there's a very long-winded process to do this, and people will be accepting submissions to go in and apply to the Supreme Court, and eventually they get heard before their judge panel.
Yeah, but initially they have a hearing, which is about whether there's actual approval to move on, isn't there?
Yeah. Well, they have to submit things, and like each side submits it, and then there's intervener status. There's all sorts of things that could be put into each of the court levels.
Yeah.
Like at an Ontario Court of Appeal, there was an intervener status with one of the cases that we've been following, around immigration and paralegal. And it's very interesting because like our association has actually put in an intervener status in it.
Yeah.
Yeah. And it's important to do these things because then we can make our own arguments in the appeal. Like, it doesn't necessarily have to be in support of whatever the plaintiff or the defendant or whoever is saying it, but you're giving information to the court that they should consider when rendering their decision. Yeah.
And the whole point is that here, of course, you're at the highest court of the land, and in a way, the court has to take into consideration all options at this point.
Yep. And this is binding across Canada.
Yeah.
Like, yes, appeal courts, like the Appeal Court of Alberta, for example, yes, it can be very persuasive to deal with a case in Ontario. Particularly if you're dealing with the same legal issues, like say the law of contracts, for example. If you're dealing with common law issues, and that same thing would be done. But if they're dealing with things like their version of Residential Tenancies Act, it would be a little bit more difficult to interpret.
Yeah, you wouldn't. Whilst you would be going to the Supreme Court to get a final decision on that matter for, say, residential tenancies, unless the law was constructed the same in Alberta or Saskatchewan as it was in Ontario, generally speaking, this ruling is only going to apply to Ontario.
There's a lot of interesting cases coming out of BC, which was good in terms of human rights law and human rights jurisprudence. Some of it actually went to the Supreme Court of Canada.
Yeah, and the other thing to note about this, we talked about the scope of proceedings within the Court of Appeal of Ontario. You've got civil, criminal, family, all potentially can go to the Supreme Court, as can potentially provincial offences, as can other administrative tribunal decisions ultimately.
Yeah, like if a landlord-tenant case, sometimes if you're looking at a basic legal question, it can go there.
Yeah.
Okay? But it'd have to be strictly a legal question, because sometimes people go in there and say, well, we just got to keep appealing it until the judge hears us. Okay? It doesn't work that way. Otherwise, everybody
That's
would
the
do
irony.
that.
Yeah,
Course,
that is, of
everybody.
course, the irony of that, isn't it?
Mhm.
By the way, apart from the level of appeal for the Supreme Court, there is also a federal court, isn't there?
Yes, there's a federal court, and that's deals strictly on federal jurisdiction.
So
So
this would be
they
criminal.
also have federal tribunals, and they
Yeah,
also have federal court of appeal, and they also have this, and that also goes to the Supreme Court of Canada.
of course. Yeah. And so the appeal from a federal tribunal will go to the Federal Appeals Court
Yeah,
of Appeal.
federal court of appeal. Yeah,
Yeah.
and then it goes up until they make a decision, and then if it goes and it's not in your favor, then it goes up to the Supreme Court. Okay? Like there's very common cases that we use for some of the federal benefits, like for EI, for CPP, for some of the federal statutes, the federal labor force. Like if you have a federally regulated workplace, there's a lot of decisions made up there. And they're very different than provincial decisions, although many of them are constructed similarly in how they deal with things on an administrative level. But you
Yeah.
have to pretty well know what it is that you're looking at. So if you go into the National Labor Relations Board, that's another thing. Canada Labor Relations Board, that's where you take an issue for certain things, same as our Labor Relations Board in Ontario, right? So
The,
there's a lot of different things.
the other thing to be noted about the Supreme Court of Canada is that the federal government can refer questions of law to the Supreme Court of Canada when there's when they're building laws or regulations.
Yep, exactly. They can do what they call a reference case,
Yeah.
okay? And they can do that. And this is one of the things. There's people who want to do, I want to do a notwithstanding clause. I just want to ram this legislation through and use a notwithstanding clause, which can only be used for certain sections of the charter, not
Yeah.
all. Okay, like right now in Alberta, we got a Daniel Smith threatening to use a notwithstanding clause to push the referendum stuff through, and that's not going to work because referendums aren't covered under that. Okay,
the other thing about that, of course, is that the role of the Supreme Court in that particular example is you're thinking about a brand new way of doing something in law, and a lot of the reason why you would have a reference case to the Supreme Court is that I've got option one, I've got option two.
Mm-hmm.
I want to know for each of these options how the Supreme Court would make a decision.
Yep. Like, for example, the issue of consultation with the Indigenous community. That's inscribed right in our Constitution.
Yeah.
What does that constitute? Okay. And how does that work out if I'm going to apply this?
Yeah.
Okay? Now they're doing something very interesting with the province of Alberta with the recent memorandum of understanding, now an agreement between our Prime Minister Mark Carney and Danielle Smith to allow for a pipeline to be constructed, shovel in the ground, September of 2027. So they're looking at it. So in the meantime, there's the consultation phase, there's the environmental assessment phase, there's all these things, and there's a basis. They decided on a baseline about how that's going to work, like between the parties. So they seem to have come up with something, right? And that's better than them not coming up with something.
Yeah, that's for sure.
Yeah, so it looks like that they're going to be working on something. So it looks, to be in a positive way, and they have to look for some private sector partners who are going to be working within that scope. And there's also an Indigenous fund where Indigenous communities can take part ownership of this.
I have to ask another question in relation to the Supreme Court. It's bijural, which basically means it operates both in English and French. But if one of the parties is only English speaking, how would that occur? Or is only French speaking come to that? Now think about it.
Mm-hmm. I don't know. Like, I think there's a requirement that they are bilingual to be appointed.
I get that, but also remember that the principal party involved in it, may only be, may only speak one language.
Yeah, but then what happens is they have their trial in that language. Okay, like their lawyers would be making the arguments, not the individual.
Yeah.
You don't go to Supreme Court of Canada to testify. What happens there? Okay?
Well, no, you don't.
What you do is argue there, but the lawyers go to argue.
Yeah.
Or if
You
you're
don't
at that level, God help you. If you actually do get that far, you can argue yourself. They actually had a guy named Robin Sharp argue himself.
And you're right. It's not about the testimony that's going to be given, because the testimony is already before the courts in other paperwork.
So if I have, if my lawyer's francophone, he's going to go there and he's going to appear before the judges and he's going to speak French, and then the judges will be speaking French, and then there will be a pos of them who will be listening and hearing and making a decision in French, and it gets translated into English too.
So there would be the judges, if there was an English-speaking judge there, they would be hearing the translation.
Yeah,
auto-translate.
exactly.
Yeah,
because they try to keep everything so that, because English and French are constitutionally equal in Canada.
Yeah,
okay?
and of course,
of our charter that allows that.
And of course, the lawyer who's, say, from Quebec is making his point. The opposing lawyer may well be speaking in English, and an individual justice on the bench might well only speak English.
Yeah, I don't think they would only have them unilingual. I believe that they have to be bilingual to be appointed, particularly from Quebec. They have to be, because I know that because that's always been an issue with Quebec. With a lot of them didn't want to learn English or be English, but we do have because I remember there was a time that I was looking into this about French and English, and English people in Quebec have just as much rights to have their own language as French people. Right? Signage, that sort of thing, that thing came under Bill 101, that sort of thing. But your services, that sort of thing, there's a lot of issues with that. And, remember where Pierre Trudeau came into that one, about Bill 101.
I would have to say that signage in English is very poor in Quebec.
I know. They seem they put the big letters in French. Then underneath the tiny little letters, you need a microscope to read. And
yes, exactly.
Yeah.
Unfortunately,
great. Around Ottawa is great. It's really good bilingual town, and you can speak in French and English, and you go anywhere that way.
Well, it's fortunate, Angela, that I already know what saute means on the highway. So there we go. All right. And thank you, everybody, for being here. This has been an interesting run through our court system. I'm sure we'll do it again at some point. If you need to contact us, you can contact Invictus Legal on 905-688-5598. Angela is Angela@weareinvictus.legal, and I'm Peter at weareinvictus.legal, and our website is weareinvictus.legal. Okay. And the other thing to cover is, Angela?
This is when you have what you heard today in Spin Legal, or whether it's in this show or others in the series, it is not legal advice. If you need specific legal advice, then you need to contact a paralegal or a lawyer.
Yeah. And it's been great having you along, and as always. And I guess we will see you next week. And enjoy your week and stay safe, everybody.